Good morning, everybody. It is a pleasure. Thank you. It's a pleasure and an honor to be here. And I mean those words. It's an honor to be here, to lend my voice to this incredibly important cause. As Brenda mentioned, I'm a criminal law faculty member here in Los Angeles at Southwestern Law School. And so I want to start by saying I hate sex offender registration laws. Yeah. You see indecent exposure is what you see on his dot on the registry. It's not just the adults, because I'm really involved in the children as well. Children on the registry, and I don't mean children who are tried as adults. They are children too. I'm talking children who are inside the juvenile justice system. Children inside the juvenile justice system, some as young as 9 and 10 years old, are put on the registry. And I want to highlight a few of those cases. They are equally heartbreaking. The first one is a young woman. Her name is Leah. She has self-disclosed. She has a blog out. She was 10 years old, and she simulates sex act with her 8-year-old stepbrother and 5-year-old stepbrother. They're fully clothed, and she's doing that. Now, maybe in your house or my house, you'd walk in the room and you go, knock it off, separate, go back to your rooms. This stepmom called the police. Called the police. They came and took her away. She has to register for 25 years. She'll be on the registry till she's 37 years old, and all because of that incident when she was 10 years old. And she went on the public registry at 12. The next one is a 10-year-old boy who fondled a 7-year-old boy's penis. Shouldn't have done that. No question about that. But there are ways that we can deal with this that do not involve him having to register for life. And in those cases, it pains me to say that a court with a straight face looks at that boy and says, you know, this may seem harsh, but we think there's a rational basis for you to have to register for the rest of your life. Can you imagine having done an act at 10 that allegedly defines you for the rest of your life? Since so many people share, I'm here to tell you I stole a candy bar when I was 9 years old from a drugstore. Does that make me a thief for the rest of my life? Because yes, that's exactly, well, no, not really. I needed a different response from all of you. And then the last one is the same consensual sexual activity. So it's not just about the 19-year-old and the 15-year-old having sexual intercourse. It's about 2 underage kids having sexual intercourse. And you've heard about Romeo and Juliet laws, and I've researched a ton about statutory rape. And so, yeah, it's true. A lot of the states, they only charge as misdemeanors. 46 states still call statutory rape a registrable offense. In 46 states, you have to register for statutory rape. And if you have sex as an underage kid with a kid who's even more underage than you, as JL did, that's registration for life. 14 years old, 12-year-old girlfriend. And I'll put girlfriend in air quotes. She's 12, he's 14. They really shouldn't be having sex. We can all agree about that in the room. It's not the best way for them to be raised or to raise themselves. These are life-altering decisions. But he shouldn't be labeled sexual predator, which he is, aggravated sexual offense, which they call it, and he's registering for life. So I'm doing research on all this, and I'm living in the ivory tower of a law school, and I'm getting angrier and angrier. And I say to myself, how can I join the cause? I have a license, but I'm not a lawyer. And I so admire Janice. I so admire yesterday Gail's presentation of talking about going to the legislators, talking to the legislatures, toe-to-toe to the legislators. I admire all of you in the grassroots effort trying to change support in the community. And I say my voice is best heard talking to the courts. If I can talk to the courts and explain to them legally why they're wrong, legally how to turn this around, I think we all have a chance working all together. And so that's how I view my voice. I don't have a loved one on the registry. I'm not on the registry, but I share the notion that it's justice for all. I believe deeply in that. I teach my law students that. How can I teach my law students that and be part of a system that does this to so many people? So I wanted to share very briefly before I walk through the legal arguments that I present, the articles, most of the articles that I've written in sex offender registration law, not because I'm showing you my kids' baby pictures, which they are and I'm proud of them, but really to give you tools in your arsenal as you approach your lawyers, as you bring a case, as you walk in to talk to advocacy groups. What are the legal arguments we need to talk about? Because it's not just enough to say the court was wrong. We have to give them an avenue to make it right. And so here are the articles, some of the articles. Actually, Brenda mentioned one I don't have on here. It started in 2006. I was so upset with statutory rape as a registrable offense, I started to look more deeply into it. And I was really angered by the fact that someone could go on the registry who didn't know the age of the person they were having sex with, who thought they were of consent. I thought, okay, you have this crime, it's called statutory rape. We call it a strict liability offense because you don't have to prove the mental state. Okay, fine. But now you're putting that person on the registry. They're not dangerous. They really thought the girl was 18. They really thought the girl was 16. Well, there is a case right now going through the Louisiana courts using this article. His name is Mark Frug. And the former U.S. attorney in that area, very prominent person who's now a criminal defense lawyer, took it on appeal, and he's hoping the Louisiana Supreme Court is going to hear this case. And he used the article as his sole basis for his appeal, saying it's unconstitutional to put somebody on the registry who made an absolute mistake that everybody would agree with, who was not trying to violate the law. Once I got into that, I really got very interested in how these laws were developed. And I started to track the legislative history, what I call the legislative panic, which disillusioned me even more, because as you start to see the inflammatory language, the rhetoric that's wrapped around these laws, you have no belief in these laws. And that's the 2010 article about this legislative panic. But as I was saying this morning, and I'm going to mention Gail's name again, these sex offender registration laws, three strikes laws, all came about because of some emotionally charged voices, victims' voices, who came in, those victims' voices, who came in and got the ear of the legislature, the power of the few. Well, I'm here to tell you this power of the few can change that voice, that this power of the few can also correct the situation. That's how it works. The next article, which got a lot of play, is I went up 10,000 feet in the air and I said something terribly wrong is happening with sex offender registration laws. If they ever were good, which I never thought they were, but if they ever were good, they are so broken now, they are so bad now, they are so punitive now, we've got to talk about this. And the 2012 piece, The Evolution of Unconstitutionality, walks through the legal arguments of why they're bad. The 2010 piece and the 2012 piece both were cited by the Maryland Court of Appeals when it overturned sex offender registration laws. The good news about that is nobody likes to reinvent the wheel, and so those two articles are now being used by lawyers in their appeals. They're going to be picked up. And the Hastings piece sits on the Indiana Supreme Court's website as exactly how they believe what's happened to sex offender registration laws. The new baby that's coming out for publication now was really based upon the essay that Brenda talked about. It's a full-blown discussion of juvenile sex offender registration and how unconstitutional it is. You don't write this by yourself. It takes a village to do these things, and I'm really proud, actually, to introduce three students of mine who are here. I asked them to come to meet all of you and to come to this presentation. I want them to stand up for a moment. Nikki, Vince, and Tiffany. Thank you. These guys have mad research skills, mad writing skills, and I'll tell you what every student says when I talk to them in my seminar or I talk at a presentation. They start with, I don't know, and by the end, these three included, I say, so what do you think about this? And each one says the same sentence. They say, this is crazy. And it is crazy. So what I want to do now with our time together is I want to walk through, go down memory lane, the original sex offender registration laws, what they looked like. I then want to jump us into modern day, what's going on around the country today. All of you in this room feel what's going on around the country today. You have bits and pieces of it. And I think when you see the whole picture of what's going on today, sadly, we will feel even sicker about what's happening. I want to take a look at child sex offender registration, and then I want to give us true legal arguments, the tools that we can use to talk about all of this. The workshop yesterday did a great job of talking about Smith v. Doe, why it was wrong, and I want to take it to that next place and say, how do we get the courts to listen on what it really should be about? Here's what the original laws looked like. It started with two heartbreaking, there's a third case, but two heartbreaking deaths, Jacob Wetterling and Megan Kanka. Jacob's parents, he was pulled off of his bicycle. Mystic River is probably a takeoff on what happened to Jacob Wetterling in front of his friends. He's 11 years old, pulled off of his bike. He's killed. Megan Kanka is a true horror story. She walks across the street. Jesse Temenduquas is across the street. Basically, you want to come in and see my puppy. He brutally rapes and murders her. Those two had parents, families, who not only couldn't let go of it, they went to their legislatures. And they created the first round of national sex offender registration laws. Janice was absolutely right. California's had them, but it was for all kinds of other things. And so they created the first set of laws, and I want to bring us back to 1994, 1995, when they came into existence. They looked nothing like they look now. They were terrible, but they look nothing like they look now. Registration was meant for law enforcement. On average, there were 8 crimes that were registrable offenses, only 8. And if there was notification, this is how it looked in 1995. You had to walk into the police department. You had to say to the police department, I'm a victim, I'm a family member, I own a daycare center, I want to see the registrants in this neighborhood. You had to stay in the police department, you couldn't take any papers away with you, you weren't allowed to photocopy anything, you stood there and you had to look through the stuff by yourself. You see how far we've come? Those were the original laws, 8 offenses, and you had to stand in the police department, and you only got in, not because you were a looky-loo. This is not like a house is for sale, you've gone by to see what's going on. You only got in if you had kind of a standing. That's what the original laws looked like. Well, they got comfortable with those original laws, and so they started to expand, because that's the way legislators are. Give them a little bit, give them a little bit. And then comes the watershed year. Janice is absolutely right. Chance is absolutely right. 2003 was the year. 2 decisions came down from the United States Supreme Court on sex offender registration laws. But I want to talk about a third first, because the third gives me hope. The third is a gorgeous case. They all came out in the same summer. The third is a case called Lawrence versus Texas. Some of you may know it. It says to states, get out of the bedroom. It says to states, you cannot, you may not criminalize sodomy. You may not criminalize marginalized people's sex lives. And same-sex will not be tolerated as criminal anymore. It is a brave opinion. And if you look at that opinion, it has a lot of similarities to Brown versus Board of Education that said you can't, we will not tolerate segregation. It was written by Justice Kennedy. And at the same moment as he wrote that opinion, oh dear, he writes Smith v. Doe. At the same time as he's giving us liberty in Lawrence versus Texas, he's turning around and giving us Smith v. Doe. And Smith v. Doe, for those who weren't in the workshop yesterday, was really the seminal case in sex offender registration laws. Everybody's watching. Everybody's looking to see what the court's going to do. So there's this Alaskan model. It's not great, but it doesn't look like it looks now. And the court has to make one big decision. Is this punishment? And for those in the room who are not lawyers, here's why they have to actually decide that. If it's punishment, the 8th Amendment of the Constitution kicks in. If it's punishment, then we get to talk ex post facto and retroactive application. If it's punishment, I get to talk if it's cruel and unusual punishment. But if we never get to first base, If it's never called punishment, I can't go, but, it's retroactive. But, it's cruel and unusual. If it's not punishment, that's the end of the ball game. And so everybody was watching. And in a 6-3 decision with 3 very great dissenters, the court said it's not punishment. End of story. No discussion about anything else. Never get to ex post facto. Never get to, but there was the knock on the door and now I've got to register. I've already paid my debt to society. No, it feels like punishment to you. You know, it walks like a duck, it quacks like a duck, it looks like a duck, but we've written an opinion that tells you it's not a duck. It is not punishment. That was Smith v. Doe. The second case came out exactly the same time, It's only a few pages later in the book, equally devastating. Connecticut had decided to take all of its sex offenders, all of its registrants, and put them on the internet. And it had in very little font at the top of the page, "This does not portend future dangerousness. We're not saying these people are dangerous now. We're just stating a fact that they have been convicted of a sex offense. That's all we're saying." So registrants filed a complaint. And they said, wait a second, you can't put me on the registry until you give me a hearing. Give me a hearing that at least allows me to tell you I'm no longer dangerous. Don't put me on the registry until I get a hearing. That's called procedural due process. They go all the way up. The Second Circuit says, oh my God, you're absolutely right. Get to the United States Supreme Court in an opinion that still makes my head scratch. They go, well, here's the deal. Connecticut was never pretending to give procedural due process. They, in fact, had a lack of procedural due process. Everybody's dumped in the registry. Everybody's on the internet. And since everybody's on the internet, you weren't denied due process. That kicked off true explosion of the internet. 2003, imagine around all the country, all the legislators are looking. They're watching, they're waiting. The second those 2 decisions came down, the states went crazy, because that's what politicians do. Give them an inch, they're taking 2 miles. And now all of a sudden, they got a green light from the United States Supreme Court. Implicit green light that said you get to do anything you want with sex offender registration laws because they're not punishment. And so the legislators puffed up their chest, and all of a sudden we were off to the races. And now I want to talk about what these schemes look like now, because they couldn't get in front of that camera quick enough. They couldn't start mugging in election years for more, stronger sex offender registration laws, and it's all because of 2003. So the first thing was federal legislation. You may have seen it. You may remember it. It was a big election signing bill. Another child brutally, well, we don't know brutally murdered, but was murdered, abducted from a store, Adam Walsh, and a very strong advocate for a parent who really would not let it go. And in 2006, the Adam Walsh Act, with sex offender registration and notification subsumed in it, was passed. I want you to think of a big, bloated, extravagant beast. This is what they've created. They created a structure that is enormous, filled with so many requirements, filled with so many crimes. Big signing. President Bush, John Walsh, lots of light bulbs, and they passed SORNA. And they said to the states, not only have we passed it federally, you've got to go out and do it. And if you don't do it, you're going to lose money. And so it was marching orders for the states. You better come on board. Well, the states heard the Supreme Court. They heard SORNA. And here's what we have right now in sex offender registration laws. And I'm not telling you anything you don't know, but I want to give some fleshing out about it. We went from 8 offenses to an average of 40 registrable offenses in each state. 8 in the 1990s, 40 by the year 2008 or 2009. Things that weren't registrable before, they're registrable now. Well, you don't have to be a law professor to know that that's a net cast way too wide. That's not containment of sexual predators. That's nothing to do with people who are dangerous. That's slapping on anything that has the word sexual in it, and it's becoming registrable. Not only that, The offenses kept changing classification. So you could have been a Tier 1 offender. You wake up one morning, and arbitrarily, you've become a Tier 3 offender. Wait, you say. I need a hearing. I'm not dangerous. I was supposed to get off the registry in 2 years. No, unilaterally, we get to decide that you're no longer a Tier 1 offender, you're Tier 3. And why do we get to do that? Because it's not punishment. And we get to do all kinds of stuff retroactively. We get to change the rules. Can you imagine in a football game? Oh, you know what, I'm moving the goalposts. You're getting too close for a touchdown. We would never do that. We would never do that anywhere else except here. We're changing the rules all the time. In Ohio, oh me, oh my Ohio, I got to tell you, brave, wonderful state. The Supreme Court of Ohio single-handedly is ferreting out all this nuttiness. They came along and they said, you can't be changing these rules, Attorney General, by yourself. There's something called proper legislative power, and you don't get to decide, because it's an election year, that everything's going to be a Tier 3 offense. You have to really work through a process. As you know, it started out as 10 years in the 90s. It's now 20 years, and everything's lifetime registration. That's the mantra now. So longer periods, people on for life, more notification, more registration burdens. And I'm going to talk briefly about removal, but I'm here to say, for anybody who gets off the registry, that is kind of a misnomer, because one can be off it for purposes of registration, but kind of like turning off your TV set, the glow is always there. It is hard to remove every vestige from the internet. It is hard to get that name off of the internet. And so we could talk removal in a beautiful way, but the minute those names went on the internet, the states have an obligation to figure out how they're going to get those names permanently off the internet when that time comes. We know it applies retroactively. Again, why? Because it's not punishment. If it were punishment, you could never go back in time. Here's the interesting thing about applying retroactively, and the recidivism studies tell us this. I pass a law in 1998. The legislator says, oh my gosh, it's not enough that it starts in 1998. You need to go back and grab those people who were convicted of an offense in 1985. We are afraid of them. Well, the recidivism studies say if they haven't reoffended after 1985 to 1998, they're not reoffending. They're not dangerous. But the societal panic doesn't allow us to hear the true facts. The legislative panic doesn't allow us to listen to the real recidivism studies, so they apply retroactively. And they subject children to the registry. My title of my article is Against Juvenile Sex Offender Registration, but inside my article I never use the word juvenile. I use the word child, because I think terms are really important. And if you're 10 years old and you're put on a registry, you're not a juvenile. That kind of sounds like you're 17. You're not. You're a little kid. And anybody who has children or grandchildren know what a 10-year-old looks like. You're a child, and it applies to children. And did you know that the registry doesn't just apply to sexual offenses? So as part of my list of absurd cases, I have to tell you about Rayner versus State. I'm on a mission to embarrass the Georgia Supreme Court because this decision is absolutely terrible. So no matter what article I write, it doesn't even have to be about sex offenses. I'll find a way to bring in Rayner versus State. 18-year-old drug buyer robs his 17-year-old female drug dealer. He admits to the robbery. He absolutely admits to the robbery. He says, yes, I robbed her. So he pleads guilty to the robbery. They tack on registration for life. And he goes up to court. He goes, I'm not a sex offender. I wasn't trying to rape her. I was trying to get the money. She had a ton of money. I was trying to get the money from her. I'm a robber. I'm not a rapist. You can't put me on the registry. I think that kind of makes sense, doesn't it? Gets up to the Georgia Supreme Court, and the Georgia Supreme Court says in a full opinion, footnotes and everything, says, you know what? No. You think sex offender registration is meant to protect children from sexual predators. Oh, no. It's meant to put anybody on the registry who has a crime affecting a child victim. And so in Georgia, All kinds of non-sexual offenses, folks are put on the registry. So 18-year-old Rayner sits on a sex offender registry for a drug deal gone bad where he stole from his dealer. Florida, who I'm not crazy about, Gail has a lot of work to do. Suzanne has a lot of work to do. Eric has a lot of work to do in that state. But the Supreme Court got it right. A guy carjacks a car, jumps in the car, starts to drive off. This is his worst nightmare. In the back seat's a sleeping baby. So he looks, he goes, oh my God. He pulls the car over a little bit later. The baby's fine. He's convicted of carjacking. Fine. They want to register him as a sex offender because he took a baby. It took the Florida Supreme Court to say, no, no, no. He is not a sex offender. He's a carjacker, yes. He's not a sex offender, and we're not putting him on the registry. I get hope from a case like that that says sometimes we can have the courts. The last one is, for me, the most heartbreaking and the most dangerous. We moved from a system of risk assessment where people were not put into bins. You did this offense, you're automatically tier 1. You did this offense, you're automatically tier 2. We looked at the person, we judged their risk assessment to judge what classification they should be in. We have now moved really to one size fits all in the tiers. We've moved to conviction-based assessment. We've moved to a place where everybody in tier 1 is judged the same. Everybody in tier 3 is judged the same. We know that's not true. We know so few people are going to reoffend. And if we do it based upon conviction, we have no ability to judge the particulars. So this is what super registration schemes look like. And this is what makes me so sad. But here's part of the hope. 2006, you know that movie, If You Build It, They Will Come, from Field of Dreams? Kevin Costner was told, build a baseball diamond and the players will come. So they built SORNA, this big bloated registration scheme, and they said, you better comply, you better comply. Well, as of July 2012, those are the only states that have complied. The Ohio Supreme Court, in its most recent opinion, called this national foot dragging, that the states don't really want to comply, which is actually pretty rare because they complied with the first round of registration schemes immediately. They don't want to comply. And in fact, as of February 2013, only 16 states are complying. So why aren't they complying? First is juvenile registration. They don't want to put kids on the registry. And SORNA demands you put kids on the registry. The second, which is probably the first reason, is the cost. It is so costly. Our roads are crumbling. Educational systems are suffering. People are out of work, and you want to spend all this money on a program about reoffense that's not really happening because the recidivism studies say it's not really happening? This is crazy. State of Texas wrote a great letter, and it said, you know, we did a little number crunching. And we figured out you're going to give us $1 million if we meet this. We're going to lose $38 million to comply. So we're going to say thank you for your gift of $1 million. We don't want it. We're not complying. State of New York, same thing. State of California, same thing. And the last is no individualized risk assessment. States are saying, we know we have to do a better job of risk assessment. We really want to try to do that. And so we're not going to comply. So where it stands now is the U.S. Attorney General doesn't know what to do. So Eric Holder has been madly changing SORNA laws, madly changing Adam Walsh Act. Well, if I take this out, will you comply? If I take that out, will you comply? It is absolutely a public relations nightmare because nobody's complying. And Ohio was so mad because in the opinion, the court said, we implemented everything. We were the first state to meet compliance because we thought we had to. Then we looked back and realized everybody else was smarter than us. Nobody is doing it. And so they have found their sex offender registration laws unconstitutional. And they said, enough. We're not going along with this SORNA stuff. You know what's required of registration. I'm Canadian. Have I said A yet? I'm not sure. I am Canadian. And for a lot of years, I had to register. It's called an alien registration. I picked up a postcard from the post office. I filled out my name and address and dropped it in the mail every January 1. Did that for a number of years. Alien registration. When sex offender registration first came out, people thought it was like that. All you had to do was fill out the postcard, send it on to the police station, just let them know where you're living. We know, of course, that's not what registration looks like. It involves so much more, and it continues to involve more and add more. There's a lot of stuff happening under Fourth Amendment and First Amendment rights. Computers can be searched at any time, houses can be searched at any time, all because you're on a registry, which, I will remind you, is not punishment. Halloween, I really appreciate that Janice is fighting that other states are fighting this craziness, and that fabulous judge in Simi Valley who said this is really pretty ridiculous. And the last one there, failure to register is a felony. And for many registrants who fail to register, going back can be a third strike and can be life imprisonment. So we're not just talking about little stakes, we're talking about huge stakes. I want to stay on that last one. For anybody in here who's tried to figure out about moving from one state to the other, has a loved one who wants to move from one state to the other, or a client, it is impossible, I'm here to tell you, to figure out the registration rules when you get to that next state. It's impossible to figure out when I have to register, do I have to register, is my crime the same? And in fact, you've got to register within 3 days. There are some states that require you to register in 24 hours. You can't even unpack. You've got to go find that police department and register immediately. That's how serious and how easy it is to violate these registration laws. Remember the police department in 1995 where you walked in the station and just looked at the paper? And only a few of you could do so? Well, we know on that internet is everything. Everything, things that we would never, ever allow our information to be sitting on the internet. A registrant loses all those privacy rights by virtue of that conviction? Makes no sense. By virtue of that plea agreement? Makes no sense whatsoever. And we know it spawns vigilantism. We know it spawns further hysteria. We know it spawns bad decision-making. The internet notification system, public registration, public notification is single-handedly the worst thing that's happened. Because if we could roll it back and say, for a limited number of people, law enforcement need to know who they are and where they are, most people could agree with that. Most scholars could agree with that. But to have this open system where everybody has to register for everybody's information to be on the internet, and I walk my students only once because I think it's exploitation. I walk my students in my sex seminar. Well, that sex seminar didn't sound right, and I'm being recorded. Sex crimes seminar. I walk them through a Megan's Law look. And there's two things that happen when you walk through that Megan's Law look. The first is there are so many dots that it feels irrelevant. You look at that list and you go, oh, please, I don't even know what this means. It's so many. The other is if you start to click on, you have no idea what you're looking at because you don't know what 261 is. You don't know what 261.5 is, statutory rape. You don't know what 288 is. You got to go to the code section to figure that out. And even if you do know the name of the crime, these names have taken on lives of their own. Everybody's a sexually violent predator. I think yesterday Tom mentioned the power of language in one of the breakout sessions, and I so agree with that. We have so created vitriolic language around some of these sex offenses. So when you get on that registry and you look, you have no idea what people are convicted of. But I'll tell you, everybody who goes on there thinks people are dangerous. I don't care what the font size is, the disclaimer on that front screen, everybody's jumping there. Single worst thing that's happened to sex offender registration laws is notification. I said single worst, I was wrong. Residency restrictions are just absolutely horrible. Another example of the sex offender registration laws, I call it on steroids, super registration schemes. When I started doing the research in the 1990s, buffer zones, residency restrictions were 1,000 feet, and they were only 1,000 feet for limited places, schools, parks, daycare centers. They are now 2,000 and 2,500 feet from, here comes the laundry list, bus stops, Georgia, video arcades, I think that's Tennessee, libraries, pools, malls, and then the great phrase, any place children congregate. Any place where children gather. And in something I described in my 2010 piece, it's not a race to the bottom, it's a race to the harshest. Community after community are passing harsh laws in an attempt to force them to the next little county. And then the next county's passing more laws and more laws until we have ended up shamefully, truly shamefully, with states where you overlap and there's no place for people who have paid their debt to society to live. This is absolutely wrong. And pictures speak 1,000 words, and I have 2 pictures that I want to produce. This is the first one from our fair state of Florida, and it is under the Julia Tuttle Causeway in Miami. That Miami, so proud that they had created such great residency restrictions that the truth is folks who have come out of prison, who had no place to live because of those residency restrictions, how shameful for the citizens that they allowed people to live without running water, without electricity, without any place purposefully, even if they had the money. They're not homeless only because they have no funds. They have family friends who would take them in. They're homeless because there's no place that won't violate them. There's no place that they can live. I was very happy 2 years ago to see this become a showpiece in Dexter. I watched Dexter. I don't know if anybody else in the room does, but they showcased it. And I thought, if you're showcasing this, and they showcased it in exactly its right light, if you're showcasing this, at least it's getting into the mainstream. This is really unconscionable and wrong. But it's not just Miami. Suffolk County, New York, had a group of Tier 3 offenders, no place in Suffolk County to live. They put them in a big RV trailer and drove them around continuously. I know, we're only laughing because it's gallows humor, right? That they drove them around continuously because they had no place to keep them. And finally, they settled the RV on the police department's grounds. They had no place to live. We know that this is wrong. We know that the court can't continue to say it's okay to create these kind of residency restrictions, especially since they don't work. It's not about where you live. If you're really worried about that predator, you're really worried about Philip Garrido from California who kidnapped J.C. Dugard at 11 years old. He drove a van. It doesn't about where he lives. He has mobility. The residency restriction does nothing about that. One of the things that I learned, I was telling folks yesterday, I invited a public defender from Los Angeles who I hope can get involved in this. His name is Dylan Ford. He walks with the angels. He's fantastic. And he brought a class action lawsuit just this last year about residency restrictions. It was something I didn't know. In Los Angeles County, do you know what the definition of residency is? You will never guess what the definition of residency is. The definition of residency at that time in Los Angeles County was 3 hours. So if you fell asleep on a park bench, you violated. If you went to your mom's house for dinner and you stayed an extra lengthy period of time and she lived across the street from a school, you violated. And so what happened was homeless people had no place to sleep. They couldn't get 6 hours in any location, and they were waking themselves up and moving, waking themselves up and moving in Los Angeles County. And Dylan Ford, on behalf of a bunch of registrants, was allowed to, because that's kind of rare, was allowed to file a class action lawsuit. And it got stayed in Los Angeles, moved it down, I think, to Orange County as well. But we are not done, as Janice has alluded to, because the newest attempts, it's not just Florida, it's Southern California, are pocket parks. Have you heard about these things? Yeah, these are little slivers of parks. The word park is not even really a good term. Blades of grass and one bench, as small as they can get, and still be defined as a park. And so a couple of communities, I was glad to hear that Palmdale or Lancaster backed off and isn't doing it. But you can see in that little map how they are planning to put these parks strategically. It's not to give green space to its citizens. It's to force registrants out. And they get to do it without changing anything else because the word park is already in the statute. So they will just create parks. And these pocket parks are now springing up. And here's the problem with legislative epidemics, and I write in 2010. The minute one takes hold, you can expect it to hit in other states. Pocket parks are not going to stay in Southern California. Legislators in your states are going to be saying, this is a great idea. We want to be as tough as Southern California. We're going to institute pocket parks as well. And the media feeds in a little bit to this because it's on CNN. They're talking about it on MSNBC. Legislators don't hear, oh, this is bad. Legislators hear, oh my God, what a great idea. I never thought about it. So we have work to do with respect to these residency restrictions. So you get an idea, and this is what makes me sick when we think about everything going on with the super registration schemes. These fat, bloated, unfunded, emotionally charged schemes that nobody cares about because they affect people nobody wants to care about. But we need to care about, all of us, because I think it was said yesterday, it might be happening to registrants now. I'm here to tell you there's a long line of people it could end up happening to. It's not just about us as registrants. If it's registrants, it's about a lot of people. So what I want to do now is jump in a little bit to the legal argument, to talk a little bit about how one makes the legal arguments. And that's why my title is More is Not Always Better. Sometimes it's unconstitutional. The point of my work and the point of the advocacy by lawyers is if they were ever constitutional, they're not now. If they were ever good with Smith v. Doe, they're not now. The weight of them, the excess of them, the punition in them, they are now officially unconstitutional. And we need to be talking to legislators to roll that back to whatever an earlier, saner point is. We need to be talking to our friends and family, and we need to be telling the courts this is now officially unconstitutional. So there's two questions, a little bit of a law school class for a moment. Two questions we ask to figure out if it's punishment. Because remember, if it's punishment, we get to second base. If it's not punishment, we have to go home. So the first question is, did the legislature intend for it to be punishment? Or did the legislature intend for it to be civil? And the second question is, even if the legislature intended for it to be civil, you might have created a law that's so punitive it doesn't just walk like a duck and talk like a duck. It really is a duck. It really is punishment. It's called the intent effects test. 2 steps. What did they intend? And now let's look at the effect. Well, we'll start on the policy, or the party line is they intended for it to be civil. They have a legislative preamble, every state does, that says this is a civil regulation. We mean this to be regulatory. We mean this only to impact the public safety. We want it to be civil. They don't put it inside their criminal codes. They put it in their health and welfare safety codes. It looks civil. I'll give them this. It's not true, but I'll give them this. Because when you go back and you read the legislative hearings, when you read the comments from some of the state senators, when you look at what they're saying, I'm here to tell you it's all about retribution. It's all about revenge, and it's all about punishment. But they did the trappings to make it look civil. Okay, we're going to give a check mark to number 1. The intent is civil. So now we look and we say, is the effect punitive? In 2003, the United States Supreme Court said, no, it's not punitive. They looked at Alaska's model and they said, nah, it's really pretty still benign. It's not punitive. What I want to do is I want to walk through the Smith v. Doe opinion and what's going on today to show you what it looks like now, in the hope that we all can present why it's punitive now even if it wasn't punitive back then, and Janice is right, Supreme Court got it wrong in 2003, but even if we give them that they got it right in 2003, the mantra now is, please, you have to change because it's wrong now. So on the left side, I've got the Supreme Court opinion. On the right side, I have what's going on today. The Supreme Court said it's not punishment because they're not going to jail. They're not being restrained in Alaska. They are free to live and work wherever they want. And I think at that time, looking at the 1994 statute in Alaska, I think it may have been an accurate statement. I think it may have been true. There weren't residency restrictions. I don't think they had enough of a handle on how many people were losing jobs. And so I'm going to allow the Supreme Court its pleasure to say it isn't an affirmative disability. Okay, so let's look at 2013. Let's talk real. This is constructive banishment. If you have a full state where you can't live because of ordinances on residency restrictions, this is exactly like colonial times. It is banishment. You're not calling it banishment. You're calling it these little ordinances and buffer zones. What a nice, benign word to really mean banishment. We know that you can't move about where you want to. People have GPS monitorings, they can't live, and we know in Los Angeles County they can't stay more than 3 hours, and that is not freedom of movement. Employment opportunities are so severely limited, and just yesterday I heard so many of these stories. There is so much pain connected to registration. There is so much pain connected to notification. People who had good jobs, people who were worthy in their jobs, who maintained their jobs and had jobs when they got out, got notification hit, a co-worker talked about it, and all of a sudden they were fired. They weren't fired because they couldn't do their work. They were fired strictly because of notification on the registry. This is an affirmative disability. Justice Stevens got it right in 2003. Justice Ginsburg had it. 2 other justices had it. And I really believe deeply that Justice Kennedy will also begin to get it, because he's a man of quality thinking, and he's going to start to see what this looks like. But there is more. The Alaska model was very limited. It was 8 registrable offenses, and really there wasn't in-person registration. You kind of sent the postcard in, sort of like alien registration. It really wasn't as horrible. Well, we know that's not what's going on now. We know that the registry is filled with non-dangerous persons. We know that the registry isn't just filled with Philip Garridos. It's filled with everybody who committed a sexual and non-sexual offense. And it's committed overwhelmingly with people who will never present a danger to anybody else. And there's frequent in-person registration. This is not like 2003. More people have to go in person every 3 months. There are people who have to register every 2 weeks. There are children on the registry who have to go in person all the time. This is not the same thing as 2003. Even if we give 2003 its due, even if we say to the Supreme Court, you know what, maybe in looking at the schemes of 1990s, maybe you were right. I don't think so. I think the dissenters were right, but maybe you were right. You can't believe your words ring true now. You can't believe Smith v. Doe works now. But I'm not done. Here's the next one. The next one says, you know what? You're feeling embarrassed. I hate that word that they used in there. You're feeling embarrassment from notification. But the truth is, it's not notification. You're embarrassed because of the public nature of your conviction. That your conviction's a public record. Somebody could Google your name and find out that you have been convicted of this crime. That's why you're feeling the shame. It's coming from the conviction. Maybe in 1995, when only a few people could walk into that police department, and only a few people could look at the registry, and only a few people could read the words, and nobody had it on the internet, even limited internet, not true. Not true now. Nobody could say stigma doesn't come from notification. There are thousands of stories to say the opposite, and no matter what the court said in 2003, it's not true now. And then finally, they say it's not akin to supervised release. I don't know, it feels a lot like it's part of the sentence. It feels like it's a lot part of the punishment. You got to meet those conditions, otherwise you face going back to prison. Who could possibly call that a civil regulation? So when you look on the right side of the screen and you look at all those things, what I think we see is this growing groundswell that these super registration schemes are really their own undoing. They became more punitive, they became more excessive, they became more puffed up with themselves, and in the course of that, they moved far away from Smith v. Doe. They moved far away from what the court thought in Smith v. Doe. This is their Achilles heel. This is why they are unconstitutional. And this is what I wrote about in the 2012 Law Review article. This is what I wrote about in 2010, that we actually need to take a look now at Smith v. Doe. Not just to say to the court, please reconsider, you were wrong in 2003. We could do that. But that's not the best way. The best way to say is, even if you were right in 2003, you want to reconsider Smith now because Smith doesn't apply anymore. And I want to go back to another note of optimism. This is possible. I really believe this is possible. We've lived something like this. In 1986, the United States Supreme Court upheld criminal sodomy laws. The name of the case was Bowers versus Hardwick. And the United States Supreme Court said states get to invoke morality. They get to create morals laws. 1986. 2003, they reversed themselves and said, what were we thinking? And quite ironically, the dissent in that case, in the original case, was Justice Stevens. And he lived to be on the court to see the change from Bowers versus Hardwick to Lawrence versus Texas. He won't be on the court when it reverses itself in Smith, but I really believe it won't reverse itself. I think it will modify itself in Smith. I am very hopeful because of the noises that I am hearing down below. So that's what it looks like for the adults. And if you bear with me, everyone good for a few more minutes? Yeah. Thank you. I want to talk about the kids. I want to talk about the kids. Because most of what we've talked about and most of the fight has really been about adult registrants. There is a fabulous book out there, and I know Joshua told his story, a fabulous book out there called Raised on the Registry. There's a lot of copies, and I hope you will grab them. For many of you, the story is about adult registration. Whether it's you or your kiddo, and the kiddo could have been 19 or 20, but those were adults. I want to talk for a moment about kids. Kids sitting in the juvenile justice system. Kids in the juvenile justice system who inside the juvenile justice system are given the names JR, LT, because it's so confidential in the juvenile justice system. But while it's so confidential there, their names are being plastered in the registry. Their faces and names are being put on the registry. Oh, it's confidential inside the juvenile court. But the minute you walk outside the door, everybody in the public knows about it. And I would never, ever put one of their faces on any talk I have. That would be horrible exploitation. That would be something one should never do. Nobody, no kid's face should ever be. No adult's face should ever be. No kid's face should ever be. So here's the thing I want to say about child sex offenders. Once a sex offender, always a sex offender. Not true for adults, really not true for children. Children reoffend at the lowest rate. Studies are all over the place, but the studies run between 1% and 2% of children who reoffend. Very few children turn into Philip Garridos. Very few children become serial predators. Here's busting the myths out. Are they few adult offenders? No, not really. Are they dangerous youths? Nah, not true. Is there an assumption of deviance that's going to carry with them forever? No, that's not happening. I'm not a thief because I stole the candy bar, and guess what? The kids who committed the sexual offenses, they're not deviant because of that one offense that they did when they're 8 or 9 or 10 or 12, or consensual sex at 14 or 15. Not true at all. So how did we start with this idea? Kind of like the Dexter model serial killers. If you tore the wings off the butterflies when you were little, you were going to become a serial killer when you are older. And they took that model to kids. And they said, well, if you did a sexual offense when you're a kid, you're going to be a sexual predator when you're an adult. And in my research, I stumbled on what I think kind of is ground zero on all this. There is a phenomenal professor, social scientist at Berkeley named Franklin Zimring, who's done tremendous amount of work, like Eric, tremendous amount of work on recidivism rates. And he found a study from the 80s involving adult sexual offenders, sexual predators. And the psychologist went in and interviewed them. And one of the questions was, did you offend when you were a child? And that small group of adult offenders said yes. And so this psychologist extrapolated from that street going backwards that if you offended, yes, and it's almost 100% rate, that means that all child offenders will offend when they're adults. And that one study was picked up and carried and became the mantra of once a sex offender, always a sex offender. So why aren't they listening to the real recidivism studies? Yesterday, Suzanne and Gail and Eric talked about talking to the legislators, not getting it, kind of still holding on. Janice mentioned last night there's one silly recidivism study on adults from the New Jersey Supreme Court that used this one study in passing Megan's Law. It is the one study that is cited in all the other courts. It's in Doe versus Ports from 1995, and God bless every other state picks up this one study. Why aren't they using the 20 years worth of research that everybody else has that says sex offenders don't recidivate? It's the social panic. It's the legislative hysteria that's preventing them from hearing the truth. Not the emotion, the truth about recidivist rates. And it's hit big time in kids. We are so afraid of you. It was also coincided with, we had a big fear about kids. So during the 80s, we started to think that our kids are going to grow up, and there was coined a label called super predators, that our kids were going to grow up and ravage the streets as burglars and murderers and rapists and robbers, and we had to be tough on them. And all of a sudden, we started to lower the age for children being tried as adults. And we got down to 12 and 11 in the state of Michigan to be tried for murder. Tried for murder 2 as an 11-year-old, because we're so afraid of you. We're so afraid of the kids. And what happened in registration is all of that fear-mongering swept up the kids. And then you add SORNA, and now you have to register as a kid. There are kids on the registry, 9 years old, 10 years old in the state of Michigan. I have read so many cases, thanks to the help of my fabulous research assistants, so many cases involving 10, 11, 12-year-olds who have to register for life. How any judge can look at them and say, you are for the rest of your life, what that offense is unconscionable. It's unconscionable for us as adults. It's even worse for children. It's not true. So who are the kids who offend? Some of you are already going to know this, and I'm moving into an area that's really beyond my expertise, but based upon the research I have conducted. But the social scientists will tell you the reason they are at the lowest for risk offending, for reoffending, is because there's so many different reasons why kids commit sexual offenses. The top category, very small percentage become predators, is the tiniest group. If I had a pie chart, it would be the pocket park. It would be the sliver of that pie chart. Very few become sexual predators. Many were sexually abused as children themselves. And so while they're children trying to work through the emotional stuff connected to that, they act out inappropriately. And that acting out is a limited period of time. So it's transitory. They're acting out to get out their abuse. The next group is the group who might be 10, 11, 12, but really they're 7 or 8 in their social skills, in their impulse control, in their ability to deal with their own peers. And so that's why the 10-year-old touched the penis of the 7-year-old boy. In a little way, he was 7 years old himself. Shouldn't have done that. But he's not at risk for reoffending. What we have to do with restorative justice, with other ways, is to figure out ways to help him, help her. Then there's a group, this group I really know about. These are guys who are just committing crimes. And oh, by the way, one of them happens to be a sexual crime. Next day, they're doing B&E, they're doing burglaries. The following day, they're selling drugs on the street corner. The following day, they're intimidating people. They're just juvenile delinquents committing a whole host of crimes. These are not sexual predators. These are just kids who are committing crimes. And then finally, do you remember this phrase? We've lost this phrase. It's called playing doctor. There are some kids who are just experimenting, and for a whole host of reasons, the people who come in on the experimentation have that social panic with them or have that revenge panic, and I want to talk about that for a second. A lot of the cases involving little kids who the police are called, all involve steps who are calling the parents, calling the police. So Leah, who was 10 years old, the police were called on her 8-year-old and 5-year-old stepbrothers. It's the stepmother who called the police on her. Got to think there's something going on in that family dynamic. In her blog, Leah says, I never did any of those things, but my stepmom hated me, and that's what she did in order to get at me. My husband represents about 48 school districts all up and down California, and I can't tell you the number of lawsuits parents file. 2 6-year-olds are in the bathroom, and they take off their clothes, and they're looking at each other's private parts. They're even touching each other's genitals. 2 6-year-olds, 2 kindergartners. Okay, they did that. Okay. Parents sue. They sue the school. Why did they sue the school? You should never have let my child be exposed to that sexual offense. Look at the wording. Look at the language. Instead of saying those kids were just playing doctor, knock it off, you're not supposed to go in the bathroom, take off your clothes, and touch each other's private parts. That's called good parenting. That's what you're supposed to do. You're not supposed to sue the school because a teacher wasn't in a bathroom to stop it. So the playing doctor has really infiltrated or been excluded from the conversation on kids on the registry. So it's a mess, kids on the registry. It's as much a mess as adults on the registry. And so that's why for the past year I've been writing this article. We're sending it out this weekend. I am hopeful that it will receive the kind of worthy attention that Hastings' piece did. I am hopeful it will be a tool in the arsenal. But here's why I think legally it will work. And I want to give you 2 bits of law on it. Remember Smith v. Doe? Well, Smith v. Doe was really about adult sex offenders. And they had that whole list of reasons why it's not punishment. Just want to zero in on one of them. In Smith v. Doe, the court said, oh, your shame doesn't really come from notification. Your shame doesn't come from your neighbors knowing about it from the internet. It comes from the public conviction. And in fact, in the Smith v. Doe opinion, they use the word public 3 times. Public indictment, public trial, public conviction. Use all three words in the same sentence. They were trying to get the point across. Okay, court, that works for adults. Now let's take your sentence to juveniles. There is no public indictment for the juvenile. There is no public trial for the juvenile. There is no public conviction for the juvenile for very good reason. We actually don't want the stigma of that, me stealing that candy bar, to track me for the rest of my life. We actually don't want that stigma. So that's beautiful inside, and all of a sudden you're on the registry. So guess what? The shame is only coming from notification. The shame is only coming from registration. Smith v. Doe does not apply to children. I truly believe that. I think if the court ends up hearing the case, I think if it gets up to the court, I think the United States Supreme Court is going to have to say that children shouldn't be on public registries, because it never envisioned that children were going to be on public registries in 2003. That really wasn't the landscape then. So much of the Smith v. Doe opinion is about the transparency in public. And the second and last thing that I want to, I took it out, is the last thing is 3 Supreme Court decisions just came down the pike that say you can't have life imprisonment without the possibility of parole as a sentence for a juvenile offender. That you can't take a kid at 14, 15, 16 and say, you're so unredeemable, we're throwing you away. You can give that kid life imprisonment, but you can't give him without the possibility of parole. And in my law review article, I say mandatory registration for life is the exact same thing. You are making a judgment on a kid and you are throwing that kid away for life. And if it wasn't okay for a sentence of life, I'm here to tell you it's not okay for registration for life. So where does that leave us? I think I have a little bit more hope than Janice, but that's because I'm not knocking my head every day face to face with actual legislatures. I'm not knocking on the ground. I get to be in my law school writing my articles, hoping people are listening. But 5 states actually are listening. Indiana was the first in 2009. It's a fabulous opinion named Wallace. Quickly after Indiana came the state of Maine. The name of the case is L'Italian. Same idea. It found also that it was punishment. Wallace said, oh my God, look at these sex offender registration schemes. Are you kidding me? Between 1996 and 2009, every single year those scheme was completely changed, amended, added to, bloated, fatter and fatter and bigger. Ohio, oh me, oh my, 3 decisions. Adult sex offender registration, punishment. Attorney General, you don't get to do stuff unilaterally. And just this past year, juvenile sex offender registration laws are punitive, and you can't be giving them lifetime registration. 3 opinions within the span of 2 years. That court is on a roll. And then, of course, I have to say my favorite, because they cited me, Maryland just a few months ago, very fractured opinion, so we don't really know where they're going to land. And then Oklahoma. When you look at that list, are you a little surprised that Oklahoma? Yeah, right? Because you think, oh my God, Oklahoma, this is drive-by justice. They're just coming in there. I'm here to tell you, for me, that tells us how bad the registration schemes are. That tells us that Smith v. Doe doesn't apply anymore. That tells us they're so punitive. That's the good news. They all said they violated ex post facto. Here's the bad news. I think the bad news. They said it violated ex post facto for their own state laws. Nobody was willing to take on the United States Supreme Court. Nobody was willing to say it violates the federal Constitution as well. And why? I know why, because I have the pleasure, distinct honor of being on committees with Supreme Court justices. I talk with them a lot. They all write opinions hoping the Supremes, that's what they say, hoping the Supremes won't see their opinions, hoping it won't cause them to be certed, hoping that it's not going to go up to the United States Supreme Court to be reversed. And so they always try to fly under the radar. So it was easier to find them violating the Constitution, but their own state constitution. There's only one justice in this whole mix. It's out of Maryland. And he said, no, it's fine. You want to call it violating the state constitution? I'm okay with that. But I'm here to tell you, I think it violates the federal Constitution. And he cited the Hastings piece for those pages that said Smith v. Doe had to be overturned. And I thought at least one justice got that part of Smith v. Doe. Now, that's not 50 states. That's not even enough to make up one court. But it's that kind of argument. So what's happened is, you at the legislative level, attorneys, ACLU offices have these arguments. Everybody's saying the same thing. And hopefully all together, God willing, we can really correct some of these really horrible injustices. And I want to thank all of you for being so patient in listening to it. Thank you so much. I think we're done. Thank you. Thank you.
A brilliant presentation, Gail Baughman from CURE. We've been watching this growing trend, and I'm sure you've seen it too, where they're using the residency restrictions as essentially a banishment tool to exclude a marginalized population from communities. Is that constitutional?
Yeah, I think that it's not. But it's not under ex post facto, cruel and unusual unless we get to punishment. It's under privilege to travel interstate. It's under liberties, substantive due process. And if it may have been okay as a civil regulation at 1,000 feet, the court is going to have to tackle whether it's okay for a state to say nobody can live in this state who are a certain class of people. I think the court will have to do that. For those who do Supreme Court tracking, the court has issued 4 decisions Smith v. Doe, others, they are all nibbling around the edges. They haven't really tackled anything since Smith that really is about whether it's punishment. Carr, Reynolds, Thibodeau, they really weren't about those things. They're going to have to track the essential core.
And Catherine,
and your name, please?
Yes, Janice Palucci, thank you. For those of you who don't recognize me yet. I just wanted to add to that about some cases. And I have one in the city of Cypress right now in Orange County. Actually, I have 2 cases against the same city, one in federal court and one state court so far. And the federal judge disagreed with me about banishment. And I mean, it's really going to come down to, I need foot soldiers. I need somebody to go block by block and figure this out. So I asked the city for a map where sex offenders can live, right? And well, there's this little strip here and there's a little strip there. And I've got to have an expert. I can't even do it myself. I can't say, well, there's 3 houses here and there's 3 here. Oh, by the way, the cemetery is always available, right? Except that I have a registrant who lives in the next city over whose parents are buried in the city of Cypress. He can't go to the cemetery to his parents' grave because there's a child care center nearby.
Right.
That's the types of things that we're focused against. We're up against. There is in the case In re Taylor, which was in San Diego, where they did a fantastic job, but it took them years. And in order to win that case, and it had to do with residency restrictions being applied against registrants on parole, and they went practically block by block, and they had to say, this is the amount of housing that's available. Oh, by the way, most of that even is not affordable because it's exorbitantly priced. And they were able to convince our Court of Appeal, and now that case is in front of our state Supreme Court. So it takes a lot of evidence, not just legal work, to make that, that argument stick.
Yeah, thank you so much for that addition. I wanted to make 2 comments. One is a point of personal privilege. From afar, I have been a huge fan of Janice's, had never met her, had a chance to meet her yesterday, and my fandom has like gone skyrocketing through the roof. What a phenomenal, phenomenal face of RSOL. One of the interesting things about Smith v. Doe, I'm not surprised that the district court said it's not banishment, because they are just passing along the mantra. Smith v. Doe applies. And in fact, you can just see, it's a few lines. Smith v. Doe applies, it's not banishment, it's not banishment. It's actually going to take a much higher level court. It'll take our crazy Ninth Circuit, who is very happy to do that. They get overturned all the time, but it'll take our Ninth Circuit. The Second Circuit was eager to do it in Connecticut in the Internet Registry. So it takes a jurisdictional appellate level court, because at the trial level, very few trial courts are going to buck a United States Supreme Court decision, which is why that trial court in Simi Valley to say this is crazy is huge. It took Supreme Courts of Maine and Ohio and Maryland to say this is wrong. It was never done at that lower level. Janice is right. This is not happening tomorrow, though.
First of all, I wanted to thank you for your presentation. I thought it was very informative and wonderful. I really like the point that you brought up about the employment, with the restrictions with the employment and everything like that. And my question is that I've noticed a trend with employers, running sex offender registry checks and denying employment based on risk. And saying that they're going to get sued if they hire us or whatever. I was just wondering if you see anything in the pipeline as far as a legal challenge, as far as trying to loosen that up a little bit.
Oh, that's such a good question. There are so many aspects to it. Let me identify a few. The first is many states have something called at-will employment. And so we live and work at the pleasure of our bosses. So even in the normal course and scope, one can get fired, and a lot of states just get fired, right? The second issue is, who's going to bring this lawsuit? It has to be somebody either pro bono or with resources. And the firing of somebody or the letting go of somebody, sometimes those issues never get aired because nobody has a place to go. This is why we need organizations, we need ACLU offices, we need other kinds of public organizations to take those kind of cases, because we can't do anything unless there's a legal challenge to take the case. But if you don't have the resources or the funds, you walk away devastated, but you have no place to take that devastation.
Yes, at one time in the state of California, there used to be an indeterminate sentencing law. And after a while, the judges finally came around and turned it around and said, well, if a person is convicted of a crime, he has the right to see what he's going to get, regardless whether it was prison or parole or probation. And so they eventually turned that around. And secondly, in the 60s and 70s, they also had civil commitment for narcotics addicts. And they used to send them out into Corona. And
they sent them to Corona? What an odd pun.
And when you stopped somebody and found out they were on a civil commitment, they had done their crime time, and they would come out and be put on the civil commitment for the narcotics violations, and you found out that they were under the influence. That was enough to arrest them and take them to jail, and they would be recommitted.
I didn't know that.
So we've got to look at those aspects and how they twisted those around,
right.
And made those unconstitutional eventually.
Well, what you've actually described are pendulum swingings, right? And what's happened now is actually we now are back to indeterminate sentencing. It didn't go to determinate sentencing because the judges wanted it. It actually went to determinate sentencing because the legislators said you're hippy-dippy judges and you're giving people too much probation, and we want to put in fixed sentences. Now we've overcrowded our prisons, and so now we're going back to indeterminate. If we live long enough, things swing. However, sex offender registration is not swinging enough. One more?
I'm going to have one more. Do you have some pet research sites that you can recommend to us for those of us who are collecting and reading the studies and all of what has been referenced?
I do. They're all contained inside my articles, which are all Googleable. They're all on website online. I'm happy to post those articles on RSOL's site. Actually, that's how I heard about RSOL, because some of the independent organizations have posted my articles. But inside them is all my research. And I had asked the same question of Suzanne and Eric in Gail's presentation. They have a lot of recidivism study work, and I think the more we can use proper recidivism studies in all of our discourse, the actual truth, and we use the same ones, it's really very helpful. Thank you, everybody. Thank you so much. Thank you.